Okay, so it's 1:03, so let's go ahead and get started. I'd like to introduce Eric Blegan, the Executive Director of the Mustard Seed Project of the Key Peninsula, and he is going to say a few words. Eric.
Thanks, Jen, and thank you everybody for joining us today for our very first community forum. We're testing things out. Hopefully it'll all go well, but just thank you for joining us, and thank you, Bryana, for joining us today. Really glad to have you. So just a few words about our mission. The Mustard Seed Project's mission is to support seniors to age safely in place in their homes and in their community. And we provide a variety of programs that help with that. Transportation programs, home visits and repairs, yard cleanup programs, meal deliveries, and also information and referral through our KSIC desk. And today's program kind of fits with the information part of our mission, giving seniors the information about the resources that they need to know about. And so that's why we've had Bryana join us, and we'll be, as I said, this is our first. We'll be doing these once every 2 weeks on various different topics of interest to the community. So please come back and join the next one. Heather, I'm going to introduce next, Heather Stevenson is our program manager, and she's going to just introduce Bryana. Thank you.
Heather, I think you're muted.
Thank you. Technology issues. All right, so my name's Heather. Nice to see you all today, and thank you for joining us. I'm honored to welcome our guest speaker today, who is attorney Bryana Cross Bean. She specializes in estate and long-term care planning, elder law, and probate. She also does adult guardianships, small business formation, and real estate contracts. She has been practicing in Washington since 2013 and has a practice out of both Gig Harbor and Puyallup. Bryana, we are so glad to have you join us today, and we look forward to your informative presentation titled Getting Your Ducks in a Row, Future Planning for Older Adults, which will cover the basics of estate planning, documents including wills, trusts, durable powers of attorney, healthcare directives, and probates when those are necessary. So with that said, thank you for joining us again, and the virtual floor is all yours.
Thank you so much for the warm welcome, Heather, and thank you to Mustard Seed for having me. I enjoy giving presentations, so this is lots of fun. And so what I'll be doing today, let me just share my screen, the PowerPoint presentation, and like I said, questions will be at the end, but I will be going through the PowerPoint. If you have questions as you go, type them into the chat box if you're on Zoom, and then I'll address them at the very end. If anyone is interested in getting my slides, please contact me, and I'll include my contact information. So. All right. Heather did a great job introducing me. I've been in practice for about 8 years. What I'm talking to you about today is what I do all the time. And definitely, this is one of my passions. I really, really enjoy helping out adults and doing planning before things get into crisis. Right. And for anyone who is interested, my phone number is down here, but it's easier just to shoot me an email if you want my slides at, my email is attorneybean@outlook.com. All right, so let's just start with the basics. What is estate planning? Estate planning is the process of planning for death or incapacity through documents such as wills, durable powers of attorney, and healthcare directives. And those documents that I just mentioned are the essential estate planning documents that everybody needs, no matter their situation. So most of you probably know what a will is. That's the document that allows you to transfer property to heirs after you pass away. Durable powers of attorney allow you to appoint someone to make medical and financial decisions for you when you're unable to. And finally, your healthcare directive. That's the pull the plug document. Only kicks in when you are brain dead, in a coma, never going to wake up, never going to recover. And there's at least 3 different names for this particular document. You have healthcare directive. Sometimes you also hear it referred to as a living will. It's also called an advance directive. Okay, so going a little more in depth into each of the documents. Wills allow you to describe how you want your money and property distributed when you pass away. Tangible personal property. Washington allows you to have a handwritten list of tangible personal property. So those are things like jewelry, tools, furniture, vehicles are included in that. It's basically all the personal items that you can touch. So when I do estate planning for my clients, I always give them that list of tangible personal property. There's typically 2 columns on it. One column allows you to describe the item, and the other column allows you to indicate who you want to receive it. Now, I really like this because it's so easy to use. It doesn't need to be notarized or anything. You can add things to it, cross things out. It's very easy and flexible. Now, the residue, it's kind of a funny legal word. There's a lot of those funny legal words. That refers to everything else that's left over after debts have been paid off when you pass away. And I'll go into this a little bit more in depth later. But when you pass away, creditors always get first dibs on your assets. So they need to be paid first. And then personal property has been distributed. Sometimes someone may opt to include a special bequest in their will. So let's say that there was an adult child who was living with them and caring for them for many years. They might want that adult child to be able to remain in the home. So you can include something like that under a special bequest. And then residue, it's just everything else left over. Even if somebody says, oh yes, I know exactly what my assets are, I always like to have the residue portion listed because I've seen things come up from time to time. And it's part of my job and the way I approach things is I'm always asking, what if, this happens? What if that happens? And so when you're doing estate planning, you need to be asking yourself some kind of uncomfortable questions. So, but it's to help you prepare in case something unforeseen happens. Now, the last point on the slide, wills do not avoid probate, but do make it easier. And I promise I will get to probate. That's going to be more towards the end. But I like to kind of lay the foundation of all the documents first because it'll help contextualize probate and make it make more sense. All right, durable powers of attorney. So durable powers of attorney, that's the most important estate planning document you can have. And the reason is that it has a direct impact on you during your lifetime. The will is great, the healthcare directive is great, but nothing has quite the same direct impact on you while you're alive. And as a reminder, that allows you to appoint someone to make medical and financial decisions for you when you are unable to. This can be 1 or 2 documents. You can have what's called a general durable power of attorney, which includes both medical and financial provisions, or you can have 2 different documents. One that would cover financial decisions, one that would cover medical decisions. There's pros and cons for doing it that way. My personal preference is to have 2 different documents because it gives you more choice about exactly when it can go into effect. Maybe you would want someone to only make financial decisions for you after a doctor says that you're incapacitated, But you might want somebody to be able to come to doctor's appointments and, have a little bit more of a voice while you still have capacity. So you could have the durable power of attorney for finances going into effect on incapacity, and the durable power of attorney for healthcare going into effect immediately. Now, if you're going, and the other thing that can be beneficial about having two different documents is that you can have one person making medical decisions, one person making financial decisions. This can be beneficial if, let's say, you have one child who is an accountant and maybe another child who's a nurse. Presumably you would want the child who's an accountant to be making financial decisions and the nurse to be making medical decisions. Now, there is always a risk for having two different people performing these roles, and it mainly has to do with when they need to work together. And one of the main situations where they would need to work together has to do with, let's say you need to go into long-term care, maybe a nursing home, adult family home, assisted living facility. The person who's making healthcare decisions is going to need to evaluate what place is going to be the best for you medically. And the person making financial decisions is going to evaluate to make sure that you can afford to be there. So if they get along, no issue. But if they don't get along, then you're looking at nasty litigation. And part of the reason to do estate planning like this is to avoid litigation, have as little court involvement in general as possible. Now, for some of you, you may have older durable powers of attorney. And there was a significant change to the statute in 2017. And the main effect that had was to make sure, was to require that every single thing that your agent can do for you be listed out. This is especially true for financial provisions. So prior to 2017, and especially I would say older than 10 years, there was a lot of kind of general language that was put in to durable powers of attorney, something to the effect of, my agent, that's the person who's making decisions for you, can do any and everything having to do with my personal property or my real estate. So that unfortunately is not sufficient anymore. You need to list out what exactly they need to do. And it's a fairly extensive list. I know when I updated my durable powers of attorney to address that law change, I added 2 to 3 more pages just because the law required that. Now, a big thing with durable powers of attorney is that they are no longer in effect when you pass away. Now, that makes more logical sense for healthcare decisions because, really you can't make healthcare decisions for somebody who has passed away. Where clients of mine run into issues sometimes is that, they'll be trying to use their parents' durable power of attorney for finances to access their bank accounts after they pass away. You can't do that. That's when it's getting kicked to, a will or probate or a trust. So just know, especially for durable powers of attorney for finances, you can no longer use them after somebody passes away. Now, one of the reasons that durable powers of attorney are so important is that if you don't have one and you lose capacity, banks especially are going to require a guardianship. Sometimes your family can kind of fudge it with the doctor or hospital. They're really not supposed to, but I've seen some leniency on there. But even if you are married and let's say your spouse has just a small savings account that's in their name and that spouse loses capacity, a bank will not allow you to access those accounts unless you have either a durable power of attorney or a guardianship. So durable powers of attorney are such an important document to have. Not only if you have that, can you avoid guardianship, but also it really gives you the ability to be making choices about who you want to make decisions for you. So it's really empowering you to have control over things, even if you become incapacitated. All right, so the next document is a healthcare directive. So like I said, there's a few different names for it. Might have heard it as an advance directive or living will. Now, this only applies if two doctors have determined that you are in a permanent unconscious condition or terminal condition. So this means no hope of recovery. You're essentially a vegetable at that point. And it allows you to indicate to doctors whether you want artificial nutrition or hydration. So artificial nutrition, we're talking about a feeding tube. Artificial hydration is more IV fluid. Now, this goes hand in hand with the durable power of attorney for healthcare. So the durable power of attorney for healthcare is going to have a provision saying that you consent to your agent withdrawing life-sustaining treatment. So that means that you're essentially allowing your agent to carry out the terms of your healthcare directive. And the great majority of the time, a doctor is not going to unilaterally pull the plug, so to speak. They are going to wait for your agent to sign off saying that they consent to withdrawing life-sustaining treatment. And just kind of going back to healthcare decisions in general, talking about both the healthcare directive and the durable power of attorney for healthcare. You're really giving your agent quite a bit of power, but it can be really difficult for your agent to make those decisions for you. So it's so important that you are talking with them about, what sorts of things you would want or not want, even if you're not at end of life. I view it as kind of a spectrum. Are you one end of the spectrum, you want absolutely everything to be done for you. The other end of the spectrum, if there's even a hint of no hope, you want them to withdraw life-sustaining treatment. Where are you on that spectrum? And I mean, if COVID has taught us anything, it has absolutely taught us life is completely unpredictable. So it's really important that your family has a general idea of what your philosophy is on that. All right, I always get a lot of questions about the Death with Dignity Act that some people have heard that referred to as assisted suicide. Washington does have a statute that allows that, but it's really hard to actually fully carry out. And there's some strict rules to it. So you have to be diagnosed by a physician as having a terminal condition and having less than 6 months to live. Now, the patient themselves, you have to make 2 requests for the medication to end your life 15 days apart. You also have to be fully mentally competent. And finally, you have to self-administer the medication. So be mentally competent and self-administering the medication, those can be 2 difficult hurdles to overcome. So this is not something that occurs too much. Something that I've also kind of heard about more is if this is something you're remotely interested in and you're going on hospice or you're in a hospital or in a facility, be sure that the facility is on board with this. Some like Catholic facilities, for instance, are less accepting of this. So just if you're at all interested, check with the facility and the provider to be sure that this is actually something that they would help you carry out, even just having 2 doctors come to talk to you. All right, so there are some other important documents that some people need, others don't. The documents that I just mentioned are the ones everybody needs no matter their situation. For the rest of the presentation, I'm going to be talking about some other documents that can be useful for some clients, but is by no means kind of useful for everybody. So the first document I'll talk about is called a POLST. So that refers to a physician order of life-sustaining treatment. Now, some of you may have, or some of you or your parents may have a bright green form on your refrigerator. And that's something that both you and your doctor sign, and it applies specifically to paramedics, other first responders, and to emergency rooms. And that indicates if you do not want them to fully resuscitate you. So the kind of base law that all paramedics and other first responders have to follow is that they are required, unless they see this POLST, to take any and all life-saving measures in order to resuscitate you. So this is where, let's say you have somebody acting under a durable power of attorney, that your agent under that is not allowed to tell the paramedics no in that situation. So if you are wanting any sort of limitations at all on your care, then it's important to get a POLST. And I have seen a number of POLSTs that have not been properly signed. So it's very important that you and your doctor are signing both the front and the back of that. Now, there's some overlap and some similarities between durable powers of attorney for healthcare directive, and a POLST. And a lot of people get confused about the differences. Oh, and the other thing to add into that list is a DNR. So a DNR is a doctor's order that goes into your chart. And that more applies when you are in the hospital and let's say your heart stops, that doctor's order will indicate you do not want to be brought back to life. So that's it. Typically applies to a little bit more of an emergency kind of sudden situation that would occur. The healthcare directive, on the other hand, is more in kind of a hospice end of life type situation where you've already been diagnosed as, never going to come out of a coma and or a terminal condition. So that's where life support is being withdrawn. The POLST, like I said, applies to paramedics, first responders, and emergency room staff. And finally, the durable power of attorney for healthcare, that overlaps the most with the healthcare directive and the DNR. So your agent can consent to the doctor putting a DNR into your chart. They can also consent to the terms of the healthcare directive being carried out. I'm trying to think, there's a couple more points I want to make. The first one that pops into my head regarding that is that your Washington law prohibits your agent from placing you into any sort of facility against your will. They are also not allowed to consent to sterilization, electroshock therapy, or involuntary mental health treatment. And especially regarding the involuntary mental health treatment, there are a lot of hoops that have to be jumped through, and that turns into a legal process. All right, so the next document is a community property agreement. So most of you have probably heard that Washington is a community property state. And what that means is that there is the presumption that any property that you acquire while you are single is your own separate property. So belongs only to you. And that all property that you acquire while you are married is jointly owned with you and your spouse. The main exception to this is an inheritance. So an inheritance is presumed to be your own separate property, whether you are married or single. Now, what happens a lot is, let's say you're married, you receive an inheritance, and you place the money from that inheritance into a joint bank account with you and your spouse. If you and your spouse later get a divorce, then that's where things sort of become a little bit muddled, because it's kind of your separate property, but you also kind of made it community property. But anyways, what a community property agreement does is it converts all property that is only in one of your names into both of your names. And the practical effect is that after the first spouse passes, unless your will indicates otherwise, it just makes transfer of assets a lot easier, because it gives you the ability to access any assets that are only in your deceased spouse's name, and you can transfer those into your name. And it also allows you to take their name off of any jointly owned assets, like a home, for instance. This can result in Medicaid ineligibility, and I'm going to, part of the reason why I'm doing 2 presentations, and I think my next one is in about 2 weeks, is because there's a lot to cover. And I will be going thoroughly in depth in that presentation about Medicaid and long-term care. So if you have any questions regarding Medicaid, I highly encourage you to come to my next presentation, because I will go very much in depth, and that is its own can of worms, and the rules get really complicated. Another important document is a disposition of remains document. So that tells your funeral home what you want done with your body when you pass away. And the instructions for this used to be included in your will a lot. That is not done anymore, because funeral homes will not accept your will unless probate has been opened. And probate will normally take a few weeks to be opened after you pass away, which obviously your family is needing to make decisions immediately. So they're not, the will just is not sufficient for that. Some people need this document, others don't. There is a kind of default hierarchy of people who get to make final arrangements for you after you pass away. And this assumes that you don't have prepaid arrangements. Prepaid arrangements, you can normally indicate who you want to make those decisions. But let's say there's no prepaid arrangements, no disposition of remains. So the first person who gets to make decisions regarding that is your spouse. If you do not have a spouse, then it goes to the majority of your children. And this is where things can get dicey sometimes, and why sometimes people will end up wanting to get this document, because your kids have to agree. If you have, let's say, 2 kids and they hate each other and will not agree at all, then it's really important that you get a document like this, so they're not starting to fight right out of the gate. This can also be good for people who don't really have family, so they can, appoint a friend, for instance, to make these decisions. Right. Finally, guardianship, it's a last resort if you don't have a durable power of attorney. This is a legal process where somebody brings an action in front of the court to determine whether or not you have capacity to make medical and financial decisions. Now, ultimately, it is the judge who makes this decision. Now, there's somebody who conducts an investigation and everything else regarding this, but and talks with doctors, but ultimately it is the judge deciding whether or not you have capacity. If they decide that you do not have capacity, a guardian will be appointed for you. Now, a guardian can be, the same person who brought the action, Or if there's nobody willing to step in, or there's nobody that the court deems suitable, then you can have what's called a certified professional guardian who makes those decisions for you. And that person is a stranger. So once again, kind of going back to the durable powers of attorney, it is so important that if you don't do anything else, you get a durable power of attorney in place. And one additional point I want to make before I dive into trusts is I've had people say to me, oh, I don't need estate planning because I don't have an estate. That's not true. If you have two pennies to rub together, you have an estate. And even if you don't want to get a will or a healthcare directive, at least get the durable power of attorney so you don't have to do a guardianship. Okay, so trusts. There are two main categories of trusts. There are standalone trusts and testamentary trusts. The standalone trust is a trust that goes into effect before death and is not contained within a will. Most common one is a revocable living trust. Now, a testamentary trust, and that's always kind of a mouthful to say, is it means that it's a trust contained within a will. So that that can be especially useful. Oh, and I think that's actually on my next slide. So we'll talk about standalone trusts, and then I'll talk about some different testamentary trusts. So most of you have probably heard of a revocable living trust. It's kind of how it sounds. It can be revoked or changed while you're alive. A couple big reasons why someone might want to get it is that helps avoid probate, and it can also help avoid inheritance of stepchildren. Now, with trusts in general, especially standalone trusts, they can be good for some people. They are not good for everybody. And I've unfortunately seen far more problems with them than I've seen them being beneficial. Like I said, they can definitely be beneficial for some people, but part of the reason I've seen so many issues with them is that with a revocable living trust, you want to view it as a box that you put things in. So the only way to avoid probate with a revocable living trust is to have the proper things in the box. And what I mean by that is that you would need to do a new deed to transfer the property into the trust. So instead of your house being owned by Jane Doe, it is owned by Jane Doe, trustee of the Jane Doe Revocable Living Trust. So that's a new deed that has to be done, naming the trust as the owner. I do like this for avoiding disinheritance of stepchildren. So unfortunately, you know, I see this kind of thing more than I would like to. And this is especially true for people if they have gotten remarried when their adult children, or when their children are adults, so that they haven't grown up with each other and there hasn't been quite that parent-child relationship with the step-parent. And what can happen is if they just have a will, then that parent can go in and disinherit their stepkids after the first spouse passes away. And this assumes that you have a reciprocal will in place where everything goes to each other and then goes equally to the kids. That's a pretty common way to do things. So unfortunately, that can result in disinheritance. While there are problems with this, another good purpose of this can be if you have real estate outside of Washington. So while probate in Washington is not that big of a deal, when you start having to do multiple probates in multiple states, that's when it starts getting very time consuming. And I'm keeping track of the time a little bit. I realize I'm getting a little bit short, so I'm just going to move things along a little bit. Right. Another type of trust are irrevocable trusts, and there's a lot of different kinds. They're kind of an alphabet soup of them. But the main idea behind all of them is that they cannot be revoked or changed. Once you get them set up, there's very little that you can do to change the terms. And irrevocable refers to the terms of the trust, not necessarily to what's in the trust. The primary purpose of most irrevocable trusts is to avoid assets from taxation or from creditors. So two of the main types are for estate tax protection. And that's normally when you're wanting to do it if you have at least $5 million in assets. Washington does have an estate tax that kicks in at $2.2 million per person. So normally if you're a married couple and you have, $5 million, there's normally some very effective ways to avoid it without having to go through doing a complicated irrevocable trust. Another way to use an irrevocable trust is to assist with Medicaid eligibility if done 5+ years in advance of needing Medicaid. So like I said, come to my next presentation, that section will make more sense. All right, so there's a few different kinds of testamentary trusts that I do fairly often. One of the ones that I like to use is a special needs trust. So this is for somebody who is on government benefits, maybe Medicaid, SSDI, anything else. And it allows for the preservation of their public benefit eligibility, because instead of them inheriting directly, which would give them too much money and make them lose those benefits, then it goes into a special account for them. And whoever's managing that can take money out to pay for things that the government benefits don't cover. Educational trusts and spendthrift trusts, those overlap a little bit. I have a lot of clients wanting wanting a spendthrift trust with an educational provision. So this is helpful if, so for the combo that I was talking about, if you have an heir who's fairly young and they're likely going to be going to college, but you don't want them to get everything outright. So you can indicate that money from their inheritance can be used to pay for their education. And then after they get to be a certain age, then they can receive all or a portion of it outright. So most common ages people give me that they think that their child or grandchild is responsible enough is typically age 25, 30, 35, or 40. So lots of different options for that. A kind of pure spendthrift trust is for a child who's a little bit older and maybe just is not good with money at all, and you don't want to give them a lump sum. You can say that they get, let's say $1,000 per month until the money runs out. So the educational and spendthrift trust, lots of different options for how you can customize it. That'll work best for you. All right, so I promised you I would talk about probate, and the time has finally come. So probate is the legal process of paying off debts and distributing assets after somebody passes away. So it is a legal process. However, it's fairly simple and straightforward. On average, it lasts 4 to 6 months. That's actually one of the shortest in the country. You'll see a lot of people like in California or some other states that have an atrocious probate process doing revocable living trusts. And if you live in a state like that, then a revocable living trust would be a really good option for you. Washington, you don't always need it. Now, there's very little court involvement with it. Typically, you are, or rather pre-COVID, me as the attorney would only be appearing in front of the judge once, and that's typically for 5 or 10 minutes to ask them to appoint my client as executor. There are some ways to avoid probate, and usually for a client, if there's an easy way to avoid probate, that's what I'm going to recommend. So you can, one way is to have an estate worth less, oh, and sorry, that should be $100,000. I forgot a zero on there. If you have an estate that's worth less than $100,000 and no debts, you can do something called a small estate affidavit. And that's a really easy, simple thing to do to help distribute assets. You could also have a community property agreement, which I spoke about earlier. You can also have a revocable living trust. And finally, have only assets not subject to probate. So there are certain assets that pass directly to beneficiaries after you pass away. Main examples of those are life insurance policies, IRAs, 401ks, some investment accounts where you're listing beneficiaries. So you're listing an individual, which means that they would just provide your death certificate to that company and they can receive the assets. I'm a big fan of listing beneficiaries on accounts if at all possible. Another way that's to have assets not subject to probate is to have jointly owned assets. So some of my older clients who have been widowed will put, one of their children on their bank account, for instance. And so that child is a co-owner of the bank account and will automatically get that when they pass away. You can, if you don't want somebody having kind of a direct ownership interest, you can also do a payable on death designation through your bank. That's very easy to do. One additional way that I hadn't listed here is if you pass away having more debt than assets. So, for instance, let's say you pass away, the only asset that you had was a home and you owed more money on it than it was worth. That's when I'll tell an heir to walk away, because at that point, then the mortgage company steps in and they're trying to essentially be first in line to be able to get their money back. So unless you are a big company like that, if a loved one passes away with more debt than assets, just walk away. Probate is not required, and you are not, as if you are a child or a non-spouse, you are not personally liable for any of your loved one's debts after they passed away, unless you have co-signed with them. Like if you co-signed on a loan, then you're legally obligated to pay that loan off after somebody passes away. Okay, so trusted administration, and this has been a little bit of an epiphany for me, and it's only because I've been doing this for such a long time. And I have so many people saying, I want to avoid probate. I want to avoid probate. And I've done enough trust administrations now to realize that there's actually a lot of similarities between trust administration and going through probate. So similar components: you have to pay off the debts. You have to determine what assets a deceased person had. You have to clean out their home, distribute personal assets. If the home was owned, or if somebody owned a home, you have to either sell it or transfer ownership to an heir, distribute money to an heir, handle family disputes. Sometimes that can be the worst of it. And then finally, filing tax returns. So the main difference is that there's no court involvement. Now, I think when people say that they want to avoid probate, what their ultimate goal is that they want to make things as easy on their loved ones as they can after they pass away. And so, in my opinion, the easiest way is to be sure you don't have any assets that are subject to probate. And sometimes that's just not possible. But if things are fairly simple and straightforward for you, let's say you have 2 kids, they get along, they're fairly responsible, you can just list them as being beneficiaries on everything. And that can be one of the easiest ways to just make things super easy. Okay, so I'm gonna stop sharing. That is all I have as far as my presentation. Looks like I finished up pretty much on time. So I'm gonna pull up the chat. Doesn't look like anybody has popped in any questions, but I would like to open it to any questions that people have.
Perfect. Thank you so much, Bryana. That was just amazing and so much information and content. Yeah. I do have some questions myself, but I wonder if anybody else on here has questions. I don't see anything in the chat either, but anyone have any questions? All right, well, I'll lead with one. I wonder if your services work best for those like in Washington State or Pierce County, or if it goes beyond that.
Sure. So I am only licensed to practice in Washington State, but I've had clients from a number of different areas of the state. And oddly enough, the pandemic has made that a little bit easier because prior to COVID, I had not done any client meetings via Zoom. I'd only used it once or twice. But I have a number of like Seattle clients, for instance, where we do everything via Zoom, and then I can mail the documents to them with signing instructions. And so we're able to do everything like that. And one brief point I want to make, Washington does not allow for estate planning documents at this point to be electronically signed. What's interesting though is that there's currently a bill before the state legislature, and I know it just got passed in the Senate. I need to see where it is in the House, to allow for electronic will signings. So it'll be kind of interesting to see where that goes.
Times are definitely changing.
Yeah, and that's why it's really important to be getting your estate planning documents at least reviewed once every 10 years or sooner if you have a significant life event. So that would be marriage, divorce, birth, death, significant decline in health, things like that.
Okay, and I've got another question here really quick. How long does it take typically for a new client to get set up with those basic documents?
So it partly depends on my schedule. Normally we're doing 4 to 6 weeks.
Okay, thank you. Mm-hmm. Anyone else have a question? Oh, Maureen, you're muted.
I don't have a question. I just want to say that Bryana recently reviewed and updated some of our planning documents, and it was smooth and easy, and she answered all of our questions without any hesitation and made us really comfortable with what was going on. So I highly recommend her services.
Thank you, Maureen. And you and your husband were a delight to work with.
All right. Well, if there's no other questions, I definitely want to mention the next opportunity to listen to another presentation by attorney Bryana Cross Bean. It's coming up in 2 weeks on Thursday, March 18th. Also at 1 o'clock. Go ahead.
I did see a question come through from Marion. So the question is, understanding that there is a range, what sort of cost might someone expect to pay to get started on these documents? So great question. It really depends exactly what you need. So if you need, let's say, just your durable power of attorney for finances updated, for a single person, I'll charge $300 all the way up to like a married couple, estate planning. You're looking at closer to $1,000. If you're wanting a trust, that costs a little bit more. You're looking at closer to $3,000. So that's the kind of thing. If anybody is interested, give my office a call. You'll be initially talking with my paralegal, Heather. She's wonderful, and you can ask her any of those questions. I typically charge flat fees for estate planning, so you'll have a pretty solid idea of how much it'll cost. Yeah. Anybody else?
Looks like that no more questions, but thank you. I just want to add my gratitude, Bryana. Great presentation. And yeah, for everybody listening, please tune back in a couple weeks.
Yeah. Well, thank you all so much. It was a pleasure. And I'll just kind of stay on, I guess, for a couple more minutes and just to be sure there's nothing else.
Great.
All right.
All right. Thank you.